Good afternoon. Good afternoon. It's a wonderful day. It's a day that looks like it's going to storm again. I hear the thunder, but that's all right because God is protecting us, and I thank Him so much. And I am praying for all of the people who have been in the storms, and the storms have there have been misfortunes that have happened in the storm, and I do pray for everyone. I pray for everyone. Ask God to continue to protect us and to for all those who are experiencing tragedies and everything. I'm praying for you too, that God will comfort you and will help you to be able to make it through. I am really praying. So, dear God, as I sit before you to speak, I pray to you that my soul you will keep. And if I should die before I finish, I pray to you, dear God, in the name of Jesus, that any outstanding sins will be forgiven. Amen. Amen. And today I'm going to talk about to sign or not to sign. That is the question. Are we obligated to sign a release of liability? I want to talk about that because right now I'm going through something, and I won't say going through, but I had to make a decision. And so there is, people want you to sign, and I understand that because there are points when we have to, if we have a contract, we have to be specific, and then there might be a part in there where people have to sign a waiver or whatever. They want our products or whatever, but we have to make it plain, okay? And I'll go into all of that. But this particular consent agreement, that's what it's called, and for the service. And so I want the service. The service was recommended to me, and I want the service. I thought somebody shooting. I filed an application for the service, and they sent this to me. And when I sent the application back with my fee, application fee, and everything else, they sent the form back to me. Said I had to they wanted me to sign it and get it back to them, along with a couple of other things that they wanted. So I had thought about it even when I read it the first time, and I said, no, no, that's too much. So I'm going to read it to you. So what? The to sign or not to sign? That is the question. I had to make a decision for myself. Okay, are we obligated to sign a release of liability? And so I'm going to talk more about this when I read this to you. And I'm not going to name this organization. I'm not going to name it because I believe these organizations, many of them are doing great jobs. They're helping people. But then people need to be informed, and they need to know that you don't have to sign your life away. You don't have to. People need to be responsible for their actions. And if something would come down, when I read this to you, then I'll talk a little bit more about it. Okay, so it wants me to put my name in there, and it wants me to put my name in there. Fully understand the conditions of this organization, okay? And I understand that by signing this form, I am giving up my right to assert any claim or demand against this particular organization for damages of any type arising out of the services provided to me through the effort and assistance of this organization. All right? So, in consideration for being permitted to receive the services provided by signing below, I do forever release, you hear that? Forever release, hold harmless, and the organization, discharge the organization. Let's see, the phone rang. I do forever release, hold harmless, and discharge this organization, its officers, directors, agents, volunteers, sponsors, employees, successors, and assigns from any and all claims, causes of action, damages, demands, or liability arising out of or connected in any manner arising out of my receipt of services. By signing below, I acknowledge and agree that this organization agreement to offer limited assistance for diagnosis and treatment does not obligate this organization to provide assistance and treatment for whatever I am uh, whatever I am looking for. Okay, and then they have in bold letters, by signing below, I acknowledge and agree that this organization has the right, in its sole discretion, to refuse to provide or withdraw assistance in the event it determines that misrepresentations regarding my information have been made. In addition, failure to comply with updating certain materials and things, you'll be dismissed from the services of this place. Okay? And now, what it's saying here, that it wants me to sign, and others, I'm sure they've signed. I have carefully reviewed this agreement and am signing it of my own free will and not under duress or coercion of any kind. I am competent to sign this waiver. And then it goes on to say, this release is made and intended to bind me as well as my heirs, executors, administrators, and assigns. This agreement is made in Texas and is intended to be construed under Texas law. And of course, after thinking about it and everything, and I said I would be lying if I signed it because now I am under duress and I am being coerced to sign it if I want the treatment. So I feel like that they won't treat me or give me that service uh, if I don't sign the release, and then it's bothering me. So if I do sign it, that means I'm signing it under duress because I don't want to sign it, but I do want the services, and I feel like if I don't sign it, they won't give the services. But then I just said, well, I'm not going to sign it. I'm not going to sign it. So if I have to go somewhere else and do this, I'll just do it. But I will not be forced to sign my rights away because anything could happen. Not saying that anything will happen, not saying that something will happen, but if it does, it's saying, and then it's saying that my family, nobody connected with me has a right to hold them liable for anything that might happen to me, if anything would happen. And we've heard of things happening, we've heard of things, complications and all that. I'm not looking for anything to happen or whatever, but I do have a right not to sign my life away to somebody, just put my life in their hands and say, okay, duh, do whatever you want to. I won't hold you responsible. And I can't do that. I can't do that. And so, what my thing is, to sign or not to sign, that is the question. Are you obligated to sign a release of liability? And if they're reasonable, you understand? If they're reasonable. But let me go into this. What is a release of liability? Okay, here we go. A release of liability is a legal agreement between parties in which one party waives the right to hold another party responsible for potential damages or injuries. When a party, that means the releaser, signs the waiver of liability, they are acknowledging that they understand the risks associated with an activity and will not sue the other party. The releasee, that's who the releasee is, should an injury occur. And then there are other names for this release of liability. There's the waiver of liability. There's a general waiver. There's a hold harmless agreement. There's a liability exemption. There's a discharge of liability. There's a legal release. There's exemption for responsibility, exemption of liability, exoneration from responsibility, exoneration of liability, exoneration of liability, exculpatory clause, conditional and unconditional waiver form, and liability waiver form. So there are so many ways that they can word it. So what is included in release of liability? And this is coming from Contract Counsel, contractscounsel.com. What is included in release of liability? A release of liability can be formatted as either a standalone document or as a part of a larger contract. The content of the waiver should be specific and customized to the situation for which it is being signed, but every general release form should contain the following key components. It should catch the names and addresses of both parties, and it did have that. It wanted me to insert my name in there. And it is important to make sure it is clear who the release applies to and which party is the releaser and which is the releasee. It is common to include a date in which the agreement is entered near the names of both parties. And then there has to be the definition of terms, a section defining words within the contract is helpful so both parties understand the meanings of all legal terms used. This avoids ambiguity or different interpretations of the contract. And then there has to be a description of possible risks. It is important that the releaser is aware of the risks related to the activity and understands that by signing the waiver, they are now solely SOLELY responsible for these risks. Solely responsible for these risks. And I'm telling you, this is some tricky stuff. And you have to really, 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 really be careful with this, okay? Clear statement of release. There has to be a clear statement of release. A release of liability should include a statement that clearly articulates a statement of release. So below we're gonna have an example, okay, of what a clear statement of release may look like. So here we go. The undersigned hereby assumes all risk of injury or harm as a result of the activities specified above and agrees to release, indemnify, defend, and forever discharge the releasee from all liability, claims, demands, damages, costs, expenses, and causes of action due to death, injury, loss, or damage to the undersigned. My goodness. And then there's signatures. Every waiver of liability needs to include a signature block where both parties can sign and date the document. Some waivers will also require a witness signature, a notary acknowledgement, or both. And this one that I have, it wanted a witness and it wanted mine and a witness signature on this. Okay, now what I want to do, since I live in Texas, um, let me see what about this definition clauses. Okay. Definition clauses defined. Definition clauses, also known as contract definitions, are the defined terms in a legal document. Drafting definitions clauses mitigates the chance of misunderstanding interpretations among the parties. The defined terms section should be unambiguous and written in plain language. All right, so I am going to go here now. Since I live in Texas, I want to go with the Texas law. So, talking about what Texas court makes clear, the Texas waiver law. Because this, I mean, that is just too much. I mean, no recourse, nothing. You're going in blind, according to this waiver here. Going in blind, going in blind, and whatever goes, whatever happens to you in there, they don't want you to have any kind of recourse, and I just cannot and will not agree with that. I will not. I will not. So here is an article. It's from sportwaiver.com, and this is by uh, Doyce Cotton. It's Doyice. So excuse me if I'm not pronouncing your name like you pronounce it. Please excuse me. Note: this is a common negligence suit in which the defendant claims protection from a waiver of liability. Seldom do courts describe state waiver laws so clearly. So this is Texas, okay? So Kimberly Ramirez, while a member of a 24-hour fitness USA. Now this is on the web, this is public knowledge, and this is found at sportwaiver.com. Okay? Kimberly Ramirez, while a member of the 24-hour fitness USA Incorporated, slipped and fell when she stepped into a puddle of water on the floor. And the case is Ramirez versus 24 Hour Fitness USA Inc. 2013. Okay. Now, she sued the club alleging negligence, and the club claimed that it was not liable because Ramirez had signed a waiver releasing them. To sign or not to sign, we have to be wise, we have to use our discretion. If you have to get some uh, talk to an attorney about it before you sign it, whatever you need to do, be really, really careful. But Texas is looking up here, okay? So the following waiver appeared on the first page of the membership agreement under the heading Release of Liability, Assumption of Risk Buyer's Right to Cancel. So using the 24-hour Fitness USA Inc. 24-hour facilities involves the risk of injury to you or your guest, whether you or someone else causes it. Specific risks vary from one activity to another, and the risks range from minor injuries to major injuries, such as catastrophic injuries, including death. My. So, in consideration of your participation in the activities offered by 24 Hour, you understand and voluntarily accept this risk and agree that 24 Hour will not be liable for any injury, including without limitation, personal, bodily, or mental injury, economic loss, or any damage to you resulting from the negligence of 24 Hour or anyone on 24 Hours behalf or anyone using the facilities, whether related to exercise or not. So Ramirez contended that the waiver was not enforceable because it was ambiguous, misleading, and inconspicuous. She also claimed the waiver was unconscionable and constituted a contract of adhesion. And so, what is the Texas waiver law? So, please excuse me, let me go here and talk about the inconspicuous. I think I had that, yeah. Conspicuous. Okay, what is that? Not readily noticeable. Inconspicuous. Not readily noticeable. Okay, now let me go back to Texas. I want to get this because I don't think I'm going to be on here an hour. But I wanted to bring this because I'm really concerned about that. And I said, I'm not signing this. I am not doing this. Telling me that no matter what happens, whatever takes place, I have no recourse. They don't expect me to have a recourse. And I just couldn't do it. I would not do it. Texas waiver law. Texas waiver law is very explicit. A release of liability operates to extinguish the claim or cause of action as effectively as would a prior judgment between the parties and is an absolute bar to any right of action on the released matter. The Supreme Court of Texas has defined a release as a contract in which one party assumes the liability inherent in a situation and agrees to hold the other without responsibility for damage or other liability arising out of the transaction involved. So to be enforceable, a release must comply with two fair notice requirements, and these are the express negligence doctrine and the conspicuousness requirement. All right, so I have those. Express negligence. Here it is. The express negligence doctrine provides that parties seeking to indemnify the indemnity from the consequences of its own negligence must express that intent in specific terms in the contract. The intent of the parties must be specifically stated within the four corners of the contract. The doctrine is meant to strip away the ambiguity that some may include in a liability waiver to conceal their true intent. Now on this, I don't know what they just want me to say that they are not responsible no matter what happens. No matter what happens. Now, what is the conspicuousness requirement? It says that something must appear on the face of the contract to attract the attention of a reasonable person when he looks at it. Language may satisfy the conspicuousness requirement by appearing in larger type, contrasting colors, or otherwise calling attention to itself. Now, on this particular one, it did not have this. I have carefully reviewed this agreement and am signing it of my own free will am not not under duress or coercion of any kind. I am competent to sign this waiver. Now, it seems like that should have been in in the bold letters to me. And then this release is made and intended to bind me as well as my heirs, executors, administrators, and assigns. This agreement is made in Texas and is intended to be construed under Texas law. So those to me should have been what was in bold, but it's not in bold. And that's just before they want the signature. Okay, so conspicuousness, we just said that it should be bold, and it should have been, that part to me should have been anyway. And some people, they don't quite pay attention because they're desperate for whatever they offer sometimes. But sometimes it's best, well, all the time it's best to read before you sign. Make sure you understand before you sign. Okay, now next, the express negligence doctrine requires that the intent of the parties be specifically stated in the four corners of the contract. The conspicuousness requirement says that something must appear on the face of the contract to attract the attention of a reasonable person when he looks at it. Language may satisfy the conspicuousness requirement by appearing in larger type, contrasting colors, or otherwise calling attention to itself. And so that part down there really didn't call attention to itself. Okay? So a contract release is unenforceable if the clause involved is so one sided that it is unconscionable under the circumstances existing when the parties made the contract. And I think it is unconscionable, and I think it is very one sided. Very one sided. The people who are truly desperate for the services, some of them will sign it. And then some really won't press the issue if something happens to them. But we have rights. We have rights as human beings. And we need to exercise every single one of those rights that we have, whether it's medical, whatever. We have rights. We are people. We are human beings. We cannot just turn our lives over to someone and say, well, you just do what you want to. And then they say, duh, did I do that? Well, oh, well, it's done now. You signed a waiver. There's nothing you can do about it. We're free from liability. So we have to really, really be careful. So procedural unconscionability concerns the facts surrounding the bargaining process. The circumstances surrounding the negotiations must be shocking. Next, substantive unconscionability focuses on the fairness of the agreement itself and whether there existed legitimate commercial reasons to include the terms in question. And that's what makes me wonder why you wanted me to just coldly just say, I'm turning my whole being over to you, and whatever you do is okay with me. I don't care what you do, and I'm signing over to you. I'm not going to even try to fight you if you almost kill me. Anything like that, okay? I guess you can see that this is bothering me because I know many people have signed this contract. Okay, and it's not knocking the group, not knocking the organization, not at all. I'm not knocking any organizations, but I just want people to understand that we have rights before we go in there. And then the thing that gets me is that they will not give the service to me because I will not give them a full free course over my being. And so if I had signed it, I would be lying to say that I was signing and I wasn't coerced or I wasn't under duress because I certainly would have been. Okay, next. Substantive unconscionability focuses on the fairness of the agreement itself and whether there existed legitimate commercial reasons to include terms in question. A party asserting unconscionability of a contract must prove both procedural and substantive unconscionability. A contract of adhesion, this is according to Texas, okay? A contract of adhesion is a standardized contract form for consumer goods and services that are offered on a take it or leave it basis without affording the consumer a realistic opportunity to bargain, and under such conditions that consumer cannot obtain the desired product or services except by ex, ex, acquiescing. Okay. Now, acquiescing. Okay, excuse me. All right, got it. Contracts of adhesion are not automatically unconscionable. Next, a disparity in bargaining power may render an agreement unconscionable when one party has no real choice in accepting the terms of the agreement. However, no such unconscionability exists where a claimant has freedom of choice in entering into the agreement. So if the written agreement is signed, and if there is no circumstance that would deprive him of a freedom of choice, we see no satisfactory cause for avoiding the terms of the contract. And see this right here, where the claimant has freedom of choice in entering into the agreement. There is no freedom of choice. You either sign it or you don't. And then you might be rejected. Not saying that I will be, but I feel like I will be. I don't know. I don't know. I just don't know, being realistic. Because when I didn't sign it the first time, they sent it back to me. So if the written agreement is signed and if there is no circumstance that would deprive him of a freedom of choice, and so the freedom of choice is, I'm deprived of that, deprived of it. And then when I did get it back, then they wanted it back, got it in the mail, and then we know how the mail runs sometimes. It's not sure how many days it's going to take. I get it one day and they want it back in 2 days. And sometimes it's impossible. So if you don't get it back to us within this time, then you can't have the service. We're going to put your application aside. You can't have the service. There are always so many things that can happen. Okay? So here's the analysis of the court, talking about the Texas Supreme Court. Seeing about us, okay? Fitness USA had the burden to show that the release of liability clause satisfies the two TWO fair notice requirements. Express negligence doctrine. Fitness USA argued that the release complies with the express negligence doctrine because it listed negligence as a claim relinquished by Ramirez. Ramirez argued that the language involves the risk of injury to you or your guest, whether you or someone else causes it. Specifically, the term someone else was ambiguous and misleading because it does not specify Fitness USA, does not specify Fitness USA. The court concluded that the intent of the parties to bar actions such as those brought by Ramirez is specifically stated in the four corners of the contract. Thus, Fitness USA met its burden to show that the express negligence doctrine is satisfied. So, what are the conspicuousness requirements? Fitness USA argues that the release is conspicuous under Texas law for the following reasons. Number one, the provision is on the front page of the contract. Hello, thank you so much for being with me. Number two, the heading, meaning release of liability, is clear and ambiguous, and it is formatted in bold, capitalized typeface larger than the text around it. Number three, the heading is also positioned in a box with a contrasting background, which serves to highlight the heading. Number four, the release of liability clause is located immediately above where Ramirez signed the waiver. And number five, pertinent portions of the release are formatted to be bold, underlined, or bold and underlined. So Ramirez, on the other hand, argued that the font size of the release is too small to be conspicuous. Ramirez asserts that the release is written by 8-point font and 9-point font and is below the standard specified by Texas statute, and that's Texas Business and uh, code 601.052. Anyway, you can see that if you go to sportwaiver.com. Ramirez also argues that Fitness USA de-emphasized the most important terms of the release, a tactic that renders the express negligence language inconspicuous. The court stated that several factors help to make the clause conspicuous. The heading appears in capital letters in a box with a contrasting background. Two, it is written in plain language, release of liability. Now, this that I have right here is just, it says consent agreement. It doesn't say release of liability, it says consent agreement. All right. Now, the language of the release itself is in font size no smaller than that of the other substantive provisions on the page. Regardless of the specific point value, however, the release is of sufficient size to satisfy the conspicuousness requirement, the 10-point minimum standard provided, and then it governs notices of a consumer's right to cancel a consumer transaction, not releases of liability. And next, the most important terms of the release are bolded, underlined, or both. So, in sum, the court concluded that Fitness USA had sustained its burden to show the waiver met both fair notice requirements. So, now, Ramirez contended substantive unconscionability, claiming that there surely is a public policy in favor of seeing to it that folks have reasonable access to a safe and clean facility and to retain the right to hold the facility accountable for failing to provide a safe and clean workout facility. The court, however, seeing no oppression or unfair surprise, stated that a release of liability for negligence does not make the contract so grossly one sided as to be unconscionable. So the court concluded, as a matter of law, that the release is not unconscionable. So, what is the decision? The court ruled that the waiver was enforceable under Texas law and granted Fitness USA's motion for a summary judgment. So the court sided, they weighed everything, and they said that they had everything clear out there. Okay, and they said that they had what is the release of liability up there and all of that in bold letters. But this didn't say release of liability, it said consent form. And when we sign a consent form, that means we sign for consent for treatment and all that. And then plus the liability release thing was not in bold letters. And so I just would not sign it. And that's me. That's me. That's me. Okay, so I hope you're having a wonderful day, and it's just wonderful to be able to be here with you. Hi, Sister Leora. Hi, Sister Cleester. Hello, dear. And I'm just so happy that you're with me today. And Reedy is she has some appointments today, and otherwise, she would have been right on here with me. But she's obligated today with some appointments. So I love you all so much, and I'm not going to just continue to talk, 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 talk. But I just wanted to bring that and give you my point of view on this release of liability. Well, that's it said it's a, consent agreement. But then on down here, it has releasing all liability. And I just won't do that. I won't do that. I just won't do that. So that's my point of view for today. So what is our subject here? It says to sign or not to sign. That is the question. Are we obligated to sign a release of liability? And we know that just about everywhere. Thank you so much, Sister Leora. Thank you so much for being with me. I love you too. And release of liability. I know we know everywhere we go, they have it, but I've never seen one like this where it just takes away every right that you could possibly have and just tell you if you want to be treated here, then you release us of any liability. You have no rights whatsoever. You just come here and whatever happens is going to happen, good or bad. So, all right, everybody, I just love you so much and I thank you so much for being with me. And I pray and trust that you enjoy the remainder of your day. Thank you so much. Oh, God, I'm calling on you. Oh, God, I'm enlisting the saints to pray. Can you hear me? Can you feel me? Can you hear it?
and you feel